Chapter 6. Legal Matters Every Property Manager Must Know. Welcome to Chapter 6 of the Guide to Short-Term Rental Management. In the preceding chapters, we have journeyed through building your business, onboarding properties, and managing core operations like housekeeping and maintenance. Now we turn our attention to an area that underpins every aspect of your professional life. Legal matters every property manager must know. The short-term rental industry is dynamic, but it is also increasingly regulated. A thorough understanding of your legal obligations and potential liabilities is not just advisable, it is essential for compliant operations, protecting your clients' interests and safeguarding your own business. Overlooking these matters may result in financial penalties, legal complications, or harm to your reputation. This chapter will explore key legal considerations from licensing and zoning to guest agreements and dispute resolution. Operating a short-term rental property management business legally begins with understanding and complying with all applicable licensing requirements by jurisdiction. Several types of licenses may be required. Firstly, nearly every business, regardless of industry, will need a general business license to operate legally in a specific city or county. This is typically obtained from the local municipal government. More specific to property management, and often a point of confusion in the short-term rental sector, is the requirement for a real estate license. Whether or not you or your business needs a real estate license to manage short-term rentals varies immensely by state and sometimes even local jurisdictions. In many states, activities such as leasing property, collecting rent, advertising properties on behalf of others for a fee, or even negotiating rental terms traditionally fall under the scope of real estate brokerage laws and thus require a license. Some states have explicit exemptions for short-term or transient rentals, viewing them more akin to hotel operations, while others strictly enforce real estate licensing laws for any property management activity, regardless of the rental duration. It is important to understand how your state defines real estate activity and whether there are any provisions that specifically apply to short-term rentals. Beyond your own business and potential real estate licenses, many jurisdictions now mandate that the individual properties themselves obtain short-term rental-specific operational permits or licenses to be legally rented on a short-term basis. As a property manager, part of your service may involve assisting property owners in navigating the application process for these permits, ensuring all documentation is correctly submitted, and helping them maintain compliance with the permit's conditions. Additionally, you will likely need to register for tourism, hotel, or occupancy tax licenses or permits. This registration allows you to legally collect these specific taxes from guests and remit them to the appropriate state or local tax authorities. Laws and regulations can differ significantly, not just from state to state, but also between counties and even individual cities or towns. Furthermore, these laws are not static. They are frequently being updated, amended, or newly introduced as municipalities grapple with the growth of the short-term rental industry. Therefore, continuous research, staying informed about local government meetings, and subscribing to industry updates are vital. Most importantly, consulting with a local attorney who specializes in real estate and business licensing in your specific area of operation is an indispensable step to ensure full compliance. Closely related to licensing are the myriad of zoning ordinances, occupancy limits, and specific permit restrictions that govern the use of properties as short-term rentals. Navigating these successfully is important for lawful operation and for advising your property owner clients correctly. Local zoning ordinances dictate how land and properties within specific geographic areas can be used. Many municipalities have zoning codes that were written long before the short-term rental boom and may not explicitly address them, leading to ambiguity, while others have updated their codes to include very specific rules for short-term rentals. Some zones, particularly residential ones, may prohibit short-term rental operations entirely, or they might impose strict limitations, such as allowing short-term rentals only in an owner's primary residence, restricting the number of short-term rentals permitted within a certain geographic area or building, or limiting them to specific types of dwellings. As a property manager, Part of your due diligence when considering taking on a new property is to thoroughly investigate its zoning classification and understand any short-term rental-related implications. This information is usually available from the local planning or zoning department. Occupancy limits are another restriction that must be adhered to. These limits can be imposed by various authorities and for different reasons. Legally mandated occupancy limits are often based on building codes and fire safety regulations, which might specify the maximum number of occupants per bedroom, per square footage, or based on egress capabilities. Property owners might also set their own preferred occupancy limits for comfort or to reduce wear and tear, and short-term rental permits themselves often come with explicit occupancy restrictions. Over-occupancy not only violates these rules and can lead to penalties or permit revocation, but also poses safety risks and can lead to excessive wear and tear on the property and negative impacts on the surrounding neighborhood. Beyond simply obtaining a short-term rental permit for a property, it is vital to understand and comply with all the specific permit restrictions or conditions that come with it. These conditions can be quite detailed and vary widely by jurisdiction. Common examples include restrictions on the duration of stay, such as minimum or maximum stay lengths. For example, no less than 2 nights or no more than 30 consecutive days. Some permits limit the total number of days a property can be rented annually as a short-term rental. Certain jurisdictions have owner occupancy requirements, meaning the permit may only be valid if the owner lives on site in a primary unit or uses the property as their primary residence for a certain portion of the year. Permits also frequently include specific operational rules related to parking, such as number of guest vehicles allowed in designated parking areas, noise restrictions, such as enforceable quiet hours, and trash disposal procedures, such as specific bin types and collection day rules. As a professional property manager, your role involves conducting thorough due diligence to check all these zoning, occupancy, and permit-related restrictions when evaluating a potential new property for your portfolio. You must advise property owners on these limitations and the importance of compliance. Operationally, you are then responsible for ensuring that your marketing accurately reflects these limits, such as correct maximum occupancy in listings, and that your guest agreements and house rules incorporate and enforce these restrictions. Given that local ordinances can change, continuous monitoring of local government activity and regulatory updates is also part of your ongoing responsibility to keep your clients and your operations compliant. Understanding and navigating the requirements of the Americans with Disabilities Act and other accessibility laws is an increasingly important, though often complex, consideration for short-term rental property managers. The primary federal law in the United States addressing accessibility is the Americans with Disabilities Act. Title III of the ADA specifically prohibits discrimination on the basis of disability in places of public accommodation. Whether and how Title III applies to short-term rentals is an area that has been subject to legal debate and varying interpretations, often depending on the specific nature and scale of the short-term rental operation. A well-drafted guest agreement, or terms of service, is an essential legal tool for any short-term rental operation. This document serves as a legally binding contract between the guest and the entity making the property available, whether that is directly with the property owner or with you as the property manager acting on their behalf. Its primary purpose is to clearly set expectations for the guest's stay, outline the rules and regulations they must adhere to, protect the owner's property, and where legally permissible, limit liability. There are several key clauses that should be included in any comprehensive short-term rental guest agreement. It must begin with a clear identification of the parties involved, the guests and the host, manager, or owner, along with contact information. Accurate property details and the specific dates of the stay, including arrival and departure, are fundamental. Payment terms must be stated, including the total cost of the stay, the payment schedule, such as deposit and final payment dates, a clear cancellation policy detailing any refund conditions, and the refund policy itself. The agreement must outline check-in and check-out procedures and specific times. One of the most important sections is the house rules. This section should explicitly detail rules regarding noise levels, including quiet hours, any prohibitions on parties or events, smoking policies, and where it might be permitted, if at all. Rules regarding pets, including fees or restrictions, and distinguishing these from policies for service animals, parking regulations, and proper trash disposal procedures. Clear occupancy limits, stating the maximum number of guests allowed to stay in and visit the property, must be included and enforced. The agreement should also outline guest responsibilities, particularly concerning the care of the property and the obligation to report any damages or issues promptly. It is important to specify the consequences of any violations of the agreement or house rules, which could include additional fees or fines, immediate eviction from the property without refund, and forfeiture of any security deposit. Many agreements include a liability waiver or indemnification clause, though the enforceability of these can vary by jurisdiction and they must be carefully drafted to be within legal limits. Providing clear emergency contact information for your management company is essential. If there are specific amenities like pools, hot tubs, or fireplaces, the agreement should detail any rules or waivers related to their use. It can also be beneficial to include an acknowledgement that the guest agrees to abide by all applicable local laws and ordinances during their stay. Finally, a dispute resolution clause, perhaps specifying mediation or arbitration as a first step, can be helpful. The delivery and acceptance of this agreement are also important. It needs to be presented to the guest and demonstrably accepted by them before their stay commences. This is often achieved through a click-wrap agreement during the online booking process on your direct booking site, or by requiring an electronically signed agreement after booking through a third-party platform. Maintaining clear records of this acceptance is crucial for enforceability, as is using clear, unambiguous language throughout the document. Given its legal significance, your standard guest agreement should always be reviewed by legal counsel familiar with contract law and short-term rental regulations in your specific jurisdiction to ensure it is compliant, comprehensive, and enforceable. Despite your best efforts to provide excellent service and maintain pristine properties, complaints and occasionally legal disputes are an unfortunate reality in the property management industry. Being able to handle these situations in a professional and effective manner helps support your business and maintain client trust. Complaints can arise from various sources. Guest complaints are common and can range from issues with cleanliness or maintenance problems discovered upon arrival, to a feeling that the property was misrepresented in its listing, to noise from neighbors, or even safety concerns. Owner complaints might stem from perceived property damage caused by guests, dissatisfaction with rental revenue, concerns about poor communication, or general unhappiness with the level of service being provided. You may also encounter neighbor complaints, typically related to guest behavior, such as excessive noise, parking violations, or improper trash disposal. The first step in managing these situations is to establish a proactive complaint management system. This system should include clear and accessible reporting channels for guests, owners, and neighbors to voice their concerns. Once a complaint is received, it requires prompt acknowledgement and a thorough, objective investigation. Approaching all complaints with empathy and professionalism, even if you suspect the complaint may be unfounded, is key to de-escalation. Keep detailed written records of all complaints received, communications exchanged, investigative steps taken, and resolutions offered or implemented. When resolving guest complaints, the aim should always be for a quick, fair, and satisfactory resolution where possible. This might involve immediately dispatching maintenance to fix an issue, arranging for a re-clean if cleanliness standards were not met, offering a partial refund if a significant amenity was unavailable, or, in severe cases, offering to relocate the guest to an alternative property. Importantly, use guest complaints as a learning opportunity to identify areas where your service or property standards can be improved. For resolving owner complaints, open and honest communication is paramount. Refer back to the terms of your management agreement to clarify responsibilities and service levels. Work collaboratively with the owner to find mutually agreeable solutions to their concerns. When dealing with neighbor complaints, it is important to take them seriously as they can impact the property's standing in the community and even its ability to operate as a short-term rental. This involves promptly addressing the issue with the current guests, enforcing house rules regarding noise or disturbances, and potentially engaging in mediation with neighbors if issues are recurring. Occasionally, complaints can escalate to legal disputes. It is important to recognize when to involve your legal counsel. This typically occurs if you receive threats of lawsuits. Your contracts may stipulate mediation or arbitration as preferred methods for dispute resolution before resorting to costly and time-consuming litigation. Ultimately, the best way to navigate complaints and avoid legal disputes is through preventive measures, having strong, clear contracts with both owners and guests, maintaining open and proactive communication, consistently delivering excellent service, and keeping records of everything. This completes Chapter 6. We have covered a spectrum of legal considerations that every short-term rental property manager must be aware of to operate responsibly and protect their business. In Chapter 7, we will focus specifically on another vital aspect of risk management: short-term rental insurance demystified.